12:59.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy. Oh, what a
It's Monday. Welcome to Let's Talk Justice. My name is Jade Williams. I'm the Policy Research and Advocacy Manager at Jamaicans for Justice. We are here on another Monday afternoon. I am alone again this afternoon. Hopefully next week I won't be saying that. But we are going to be talking today about being detained at pleasure. And that is for those persons who are unfit to plea, mentally ill persons in conflict with the law, a topic that is very important to Jamaicans for Justice and a topical issue, as we would have seen a recent award in a matter related to being detained at pleasure, in that case at the Governor General's pleasure. So we're going to be talking about that in depth with John Clark, attorney at law and the board chairman of Jamaicans for Justice, and Catrian Clark, who is representing Stand Up Jamaica. So we'll get into that substantively today. Before we do that, though, we do have our right of the day and our trivia question for today. Our right of the day is related to your right to freedom of the person, and that is section 14 of our Charter of Fundamental Rights and Freedoms, or section 14 of the Constitution. It's the same, right? So no person shall be deprived of his liberty except on reasonable grounds and in accordance with fair procedures established by law. And if you look at the section 14 in the Constitution, you'll see a list of those circumstances in which there should be procedures, fair procedures established, and that would include where a person is mentally unfit to plea or to stand trial, right? And then the Constitution goes on to say, any person deprived of his liberty shall be treated humanely and with respect for the inherent dignity of the person, right? So we're talking about, one, the grounds under which you can be detained or the grounds under which your liberty can be restricted, and two, that even where it is restricted, you are to be treated humanely, right? So we're going to discuss how that right may have interacted with George Williams's case today. Our trivia question for today asks, which section of the Criminal Justice Administration Act details which orders the court can make when someone is unfit to plea? So there's a list of orders that the court can make. Once the court has established that you are unfit to plea, it can make a few orders, and there's a section in the Criminal Justice Administration Act that speaks to what those orders are. So if you know the answer, you can respond on YouTube at Nationwide 90s YouTube chat. You can respond in JFJ's YouTube chat. You can respond on our Instagram at JA4Justice, where the graphic will be posted. And you can also send a WhatsApp to 2397583. So when we talk about mentally ill persons in conflict with the law, it's something that has been at the forefront of justice discussions in Jamaica since 2020. And at that time, what we saw was a report coming out of the Independent Commission of Investigations that detailed the situation of several inmates who had been held at the Governor General's or the courts or Her Majesty, because there are several categories, pleasure for extended periods of time and had not been brought to stand trial. Now, at the time that the report was made, in 2020, it was the quarter one report. The number of inmates that were mentally ill and detained at that time was 146. Of that 146, 15 persons who were incarcerated had been incarcerated for over 30 years, and these would be persons who had no chance to stand trial. Now, since the release of that report, we would have seen some traction in terms of legal action. Jamaicans for Justice would have been there advocating for several of these victims, including, Noel Chambers, who would have been a fatality, and several others who we would have assisted in their legal matters to bring them before the court. Would have also been working in close collaboration with Stand Up Jamaica and the public law chambers. So we're going to be hearing from both of those entities today as we bring in our guests. But essentially, we would have been looking at, what were the legislative and policy reform areas that we needed to work on, while simultaneously providing that legal support to those persons who were incarcerated so that their matter could be brought before the court and appropriate orders could be made. Now, one of those inmates was George Williams, and we would have seen in recent reports that his matter, the civil side of his matter, is concluded. So he was released from custody 5 years ago, following application from John Clark, and since then we would have seen him being awarded a civil suit, $120 million for damages. Now, those damages were for compensatory damages as well as vindicatory damages. So we're going to be speaking to John Clark, who was the attorney in the matter, as well as Catrian Clark, who represents Stand Up Jamaica today, about the matter and about what we can be doing to assist those persons who are mentally ill and in conflict with the law. I don't know if we have our guests with us. Okay, so here we have Catrian. So while we're waiting on John to join us, Catrian, just first of all, what's your reaction to the result in this matter?
Hi, Jade. Thanks for having me. Well, Stand Up for Jamaica was obviously looking for more in terms of damages given to Mr. Williams. While we're grateful, thankful, and as sure as we are that he is for the amounts, it is a little, maybe I can say slap in the face, because the gentleman lost basically all of his adulthood behind bars without, being afforded the ability to go into court, plead his case. He was locked up for more than 50 years, wasn't able to work, wasn't able to, have and rear a family. All of those things that worked against him in terms of his rights being disenfranchised. I don't think that, any amount of money can compensate him for all of that loss.
I don't know if all listeners are fully aware of the matter, Catrian. If you could give them some of the facts, when was Mr. Williams detained, what for, and when did he receive that intervention so he could be released, if you have that with you.
Well, Mr. Williams was arrested at the age of 20. That was back in 1970. The charge was murder. However, he was deemed by the court as unfit to plead because of what at the time they claimed to be mental incapacitation. So he was basically held in the correctional facility for almost 50 years. He wasn't brought to court. He didn't have a court officer following up on the case. He didn't have a lawyer following up on the case. They being held in the Department of Correctional Services facilities, I mean, there's nothing that he could have done himself.
Right.
It had to be a matter where the courts followed up, or a lawyer that was appointed for him follow up, or his family. From what we understand, his family were very adamant, that he should have been at least granted a case in court, his day in court, some kind of follow-up or procedural follow through by the courts and whoever they appointed. That didn't happen. So in 2020, there was the death of Noel Chambers.
Yes.
In the correctional facility. After Mr. Chambers' death, there was a report that was done by Indicom, which basically outlined the condition that Mr. Chambers was, quote unquote, living in the facility. His body was emaciated. I mean, bed bugs, bites, everything all over. And he was said to be in a state of where he was, dehydrated. I hadn't been, taking meals for a while. So based on that Indicom report, Stand Up for Jamaica decided that we had begun before, but it was pushed. That situation, helped to push things for us, where we requested some information from the Department of Correctional Services,
right,
in terms of how many other persons there were that were facing similar fates, being locked up for an extended period with no timing in court to plead their case, and they weren't handed down a sentence. And based on the revelations that came as a result of us requesting the information, it was said that, within the correctional facility, there were over 100 persons that were in similar conditions, had been there for most of them 20 years or more, and hadn't been given any kind of, day in court or any follow-up.
Thank you for that, Katrin. I think a lot of persons are not really aware of how prolific the issue of, persons who are deemed unfit. Because it's not just the being deemed unfit. It's the being held at the court's pleasure, the Governor General's pleasure. Right. Because one of the things that you brought up was being brought back before the court. And, in a normal court case, for listeners who may not have been in conflict with the law before, when your matter is in procedure and you are in detention for the matter to continue, you come to court, you have your court date, you go back into detention, you come to court, you have your court date, you go back into detention until the matter is completed, right? So in what we would have seen happening in these cases with the mentally ill persons is that they are maybe brought before the court in an initial stage, deemed unfit. Now, there's a certain set of procedures that are to happen that I'm hoping we'll discuss with Mr. Clark if he has joined us. He has not joined us as yet. But yes, a certain set of procedures that are to follow once you are deemed unfit, that are to either help to rehabilitate you to become fit, or are to determine that you will never be fit, and then for orders to be made to manage that situation now that we know you will never be fit to play, right? So what we would have seen in Mr. Williams' case, in Noel Chambers' case, and in the maybe 13 other cases of inmates that were held for more than 30 years at the time of that report, was that those checks and balances were missing.
Were not done. Yeah.
Right. And I know, Katrin, that Stand Up works fairly extensively in the Department of Correctional Services and in the correctional facilities. We're coming up on a break now, but when we come back, I do want to ask, in your experience and in Stand Up's experience since that report, have we seen any improvements in the way that mentally ill persons are being treated in the lockups? So we're going to take the break and we'll pick up with that when we get back.
Okay.
Need reliable security for your business? Dual Protective Security is the perfect choice, providing round-the-clock security solutions and customer support. Our security experts will work with you to create customized solutions that fit your needs and budget. Contact us today and enjoy the peace of mind you deserve with their unbeatable security services. Dual Protective Security. Call 876-676-6987 or 876-415-4564.
Are you looking to drive sales and build brand visibility this summer? Be a vendor at the nationwide 90FM Back to School Fair on Saturday, July 26th at Harmony Beach Park, Montego Bay. Families from St. James, Hanover, Westmoreland, Trelawney, and St. Elizabeth will be out in full force. And you should be too. Call us at 876-630-1210 or email sales@nationwidenewsnetwork.com to secure your spot. Let's put your brand where it matters, on the ground.
Welcome back to Let's Talk Justice. Our topic for today is Detained at Pleasure, the case of George Williams, and we're discussing the detention of mentally ill inmates, as well as the recent case of George Williams, who was a mentally ill inmate that has recently received a large civil award. Before the break, we were discussing with Catrian Clark from Stand Up Jamaica about the circumstances that led to Mr. Williams's case. Catrian, I was asking you if you could just, from Stand Up's experience, what, if any, changes have been made since that Indicom report in 2020 in terms of how those detained at pleasure, those unfit to plea, have been treated in the correctional system?
Well, from what we're aware, there have been additional staffing provided by the correctional services within the prison. More psychologists, more psychiatrists have been hired. However, that's basically the gist of what has changed since this ruling. There haven't been, in our opinion, any systemic changes by the government. There hasn't been anything that have been put in writing or that we have seen, actions being taken. We haven't seen much change since the 2020 ruling.
Thanks for that. So you're saying we're seeing additional staffing, we're seeing additional psychologists, which I know was one of the recommendations that Indicom made to ensure that, they would be able to be assessed on a more timely basis, etc. That would require full-time psychiatrists and nurses to administer that treatment, etc.
Right.
But, they made some other fairly important recommendations that, those held under the Governor General's pleasure would now be held under the court's pleasure, that the office of the DPP for all cases of those unfit to plea would determine if there's still a viable prosecution against these persons, that there would be systems in place to ensure the review of those cases, and that would have to do with the court administration now. And I think most importantly, the reinstatement of a forensic psychiatric ward or facility or something of that nature. I know there was previously one at Bellevue. At the time that Indicom was making this recommendation, it was to see the reinstatement of the one that was previously at Bellevue. But I know since then, both JFJ and Stand Up would have made public recommendations to see a forensic psychiatric facility in place. Well, we've articulated our position on it, but why would Stand Up want to see something like that?
From our point of view, the having mentally ill persons in the correctional system isn't going to, quote unquote, cure their illness. All it does is to add to the overcrowding within the correctional facilities. We believe that there are steps that can be taken in terms of creating diversion programs for mentally ill persons. We're not at all saying that if they commit a crime, they are to get off scot-free. However, it can be seen that if you have mental incapacitation, there is, for want of a better word, grace that should be extended. We have been a part of a project that seeks to have a different way of dealing with mentally ill persons. That's with the Portland Rehab Management Center, where if persons are diagnosed as being mentally ill, yes, they are a part of the center as residents, but there are rehabilitation programs that they can take part in that allows them to express themselves, allows them to get the assistance, the one-on-one assistance that they need, allows them to go into areas where they can partake in livelihood activities. So in that sense, it deals with whatever mental illness they're going through, and at the same time, it gives them something, reassuring and something tangible that they can be using their time to do. And it also helps the family and the community at large in terms of when they are reintegrated into society.
So it's a more holistic response.
Right. We believe that a more holistic response needs to be done, needs to be taken, instead of just saying, okay, they commit a crime, lock them up in prison at the court's pleasure or whatever it is. That won't help. That won't help to rehabilitate them in any way.
Thanks for that, Katrin. I believe we have Mr. Clark with us now. Thank you again for joining us this week, Mr. Clark. Are you hearing me? I think your mic is muted. You might want to unmute.
Yes, thank you. Yes, thank you.
Yes. So I wanted to ask you specifically about this matter of Mr. Williams. I know you were one of the attorneys on the matter. Just for our listeners to understand, what is the procedure that should happen if someone is deemed unfit to plea and is now being held at the court's pleasure, for example?
In my humble view, I think the judgment leaves that issue completely unresolved, and I don't know the answer to that.
Yes.
Because I don't think that all law is clear on that. Because there is generally for somebody to be guilty of a crime, there are two main elements that should collide. One is the actus reus, that means the guilty act. And then there should also be a guilty mind as well. And that is a common thread that runs through a criminal law. So that means one of the elements for finding somebody guilty of a crime is that the person appreciates and had the mental capacity to differentiate between right and wrong. Now, ultimately, it is a hard pill to swallow from a public policy perspective that somebody can actually commit an act which amounts to a criminal offense, but that person should not have the consequences visited upon him or her because that person has a mental disease. And because of that hard public policy decision, the law developed in a way where even persons who have mental illness and may not arguably have the mental element can still find themselves in conflict with the law and incarcerated in custody. But the question is, where should they be in custody? At one time before the 1970s, it was clearly established in Jamaican law that persons who were in conflict with the law and needed mental treatment would have been held at a mental institution. In the middle of the 1970s, the law drastically changed, pushed by public policy, but not by an amendment to the acts themselves,
Right.
by which Bellevue no longer held persons and persons were being placed into the prison. In fact, I understand that there are papers, policy papers, which indicated why the prisons were more an appropriate facility than the Bellevue to host these people. And in fact, I understand that some of those persons were taken one day from Bellevue and brought directly to the Spanish Town prison, where some of them remain and some were eventually transferred to Tower Street. But what you have from the end is that you have persons who were brought into custody without a clear legal document as to how those persons were placed there. As it relates to Judge Williams, though, in his case, he was brought into custody by virtue of an order, not placing him in prison, but that he should remain in custody, but in custody of who? Pending a decision as relates to what would the Governor General be doing to this person. And that decision never came over 50 years, nor did Mr. Williams still trial for the offense for which he was detained. And it's important to note that this particular offense, and when one looks at the particular file for which he was arrested, that Mr. Williams was not found guilty of the offense. And in fact, he was detained months after the incident happened. When somebody said, well, it must be a madman who commit the offense. George Williams is a mad person in the community. So let us detain him. So it is not clear from the very file itself that Mr. Williams could have even been found guilty of the offense for which he was in custody, because there are many legal questions that arise factually as it relates to, is there a person who could identify that Mr. Williams was a person who perhaps did the act? But beyond those legal questions, what we have is a situation that permits somebody to be in custody for 50 years. He received an award which in some quarters, some persons may herald as sufficient remuneration for his 50 years. But then I want every listener to ask himself the question, if you were to be incarcerated, and I'm to tell you that I'm going to pay you that, or the state is to tell you that that is the only compensation you're going to get for 50 years of your life, meaning 50 years of your life gone down the gutter, unable to have family, unable to remove from your mind the trauma of the last 50 years, the experiences of the last 50 years, where we have George Williams indicate that he saw persons who were convicted of criminal offenses after he went into custody, who served the full sentence, were released, and he remained in custody. So that is the background behind which of what he was experiencing. And to complicate this matter even further, Jade, is the fact that in his particular case, he indicated, and it was on question on the government side, that he was literally serving a sentence. Because despite him being in custody as an unconvicted prisoner, the prison authorities thought he was convicted and labeled him as convicted, had him in a cell with other convicted prisoners under the exact same condition as a convicted prisoner. In fact, he said that there was no distinction between him and unconvicted prisoner and persons who were convicted. And in those circumstances, when he protested and said that he wasn't convicted, they said, oh, he's a madman. He doesn't know he was convicted. And I say that just for persons to fully appreciate the mental anguish that Mr. Williams and his family members would have encountered over the last 50 years whilst he was trying to get his liberty. And after he got his liberty, he had to endure another 5 years before he came to this judgment. And that is quite remarkable.
It's extreme, it's quite remarkable. And we're coming up on the break now, but when we come back from the break, I do want to ask you, I saw a comment earlier in relation to the matter, someone saying, Mr. Williams got such a large sum of money, and we should remember that, someone died in this case in which he would have been detained for. And so even though, in reference to the comment that it may not be a sufficient it's a sufficient compensation. They're saying even though it was not sufficient compensation, or even though you think it's not sufficient compensation, someone would have died. And so we have to also balance that and leave it as it is. So I do want your comment on that, and I'm hoping to get Catherine's comment on it as well when we come back from the break.
At the Jamaica Customs Agency, we care for our employees, customers, stakeholders, citizens, and our country. Customs cares. The temperature by the Jamaica Customs Agency is
33 degrees Celsius in Kingston, 31 degrees Celsius in Montego Bay.
The STEM Certified Robotics Training Camp 2025 will run from July 7 to July 28 at the following schools: Jamaica College, Hillel Academy, Bishop Gibson High, St. Hilda's High, Anoto Bay High, Marcus Garvey High, and Portmore Missionary Prep. The program includes robotic engineering and coding for ages 10 to 18 plus. Spots are still available, so register now at www.zjamaica.com/robotics or call 876-880-3301 or 499-3157.
Welcome back to Let's Talk Justice. We're discussing the topic Detained at Pleasure, the case of George Williams. We are joined by Catherine Clark from Stand Up Jamaica and John Clark, the chairman of the board at JFJA and attorney at law in this matter. So Mr. Clark, before the break, I just wanted to get your quick comment on, persons trying to balance the fact that there was a case that Mr. Williams ended up being associated with versus the award that he received.
I think that situation makes it even worse because those person must appreciate is that Mr. Williams does not accept that he committed this offense because he's saying this is a case of mistaken identification. One, he wasn't arrested on the scene of where this incident took place. He was arrested months after. Mm-hmm. And there's no statement, if you want to look at the file, linking him directly to the crime. So there was no ID parade where the person said, yes, this is the same man who committed the offense. But beyond that, it's also important to know that he spent 50 years in custody, but at the end of the day, he was never convicted of the offense. Yes. So all the same persons are saying overbalancing. The balancing act must bear in mind that a man is innocent until proven or pleaded guilty. He has not pleaded guilty. He has not been proven guilty. He's an innocent man in relation to those allegations. So it would be quite strange and remarkable if that allegation, which is unproven, is used to determine that any compensation for the 50 years of hell, as he described it, should be reduced on the basis that, we're balancing the allegation against. In fact, what that would mean is that he'd be punished further for something that he maintains even today that he didn't do.
Thank you for that. Ms. Clark, do you have any comment on that?
I agree with Mr. Clark. If he was never taken to court, he never pled guilty, he still maintains that he's innocent, then persons who are probably looking at it from the outside will say, but he was charged with murder, so why are we compensating him and giving him, saying that he wasn't given enough compensation? But in truth and in fact, he was never convicted. So I don't think it should be held against him, the fact that the system had him lost for years, for decades. It's unfortunate that the proper follow-up wasn't done along the years, but this is the result of him being able to get some kind of justice for the time that he spent languishing.
This matter brought to mind previously I think it was last year, we saw a matter where 6 inmates were determined unfit to plea, and the court determined they would never be fit to plea, but they could not be released because there was nowhere to release them or no safe place based on the court's determination to release them. There was no psychiatric facility. The family members were not in a position to accept them at home, and so the court had to further remand them in custody. Now, in those cases, well, I think for one, would any of those persons be, and this is to Mr. Clark, be in a position to do something like what Mr. Williams has done here and bring a matter against the state? That's the first. And secondly, what are your thoughts on the fact that the court only had one order to make in that sense? And that order is one that we would have discussed here as being one of the less positive orders that could be made in relation to persons who are mentally ill and in conflict with the law.
Well, I read that particular judgment and I suspect the court did the best it could in circumstances, and it's always heartbreaking to understand that many family members, for those particular persons, did not and were unwilling to come forward to lend a hand. And in that particular judgment, the court indicated that the citizens and the family that the persons could make contact with the public defender's office and essentially see what could be done essentially for those persons. Mm-hmm. But then I am a bit, and I think it was Nelson Mandela that said, who made the comment that a society can be judged by how it treats its most vulnerable. Mm-hmm. And I particularly am concerned about that particular judgment, because what it meant is that these persons, or they said it was Mahatma Gandhi. Society can be found in how it treated most vulnerable members. But in any event, the concern I have is that those persons are, and so they may very well be in custody as we speak. And when one reads the Correction Act, my own view, and I guess I could be wrong on that, but my own view is that the Correction Act has clear procedural guidelines in relation to how it treats persons with mental illness. And it requires the minister to take certain decisions. And then what we have in this particular case is that the Correction Act does not provide, and nor does the Mental Health Act provide, that any other prison are equipped to deal with persons with mental illness. And if they're not equipped under the Mental Health Act, then one wonders, why are we placing persons in prison for treatment? Is that prison the correct environment for treating persons who are vulnerable? And what is in place by our society, by our leaders to deal with vulnerable persons who are in prison, not because they have committed an offense, but because their mental capacity do not permit them to be able to participate in a process to determine where they should be placed. Because one must never forget that prison is the most punitive measure that the society employs. So when we punish persons, we place them in prison. When persons are questionably sick, and there's a question over where they should be placed, should you place them in the ultimate place they'll be placed if they're convicted? Because what happened for George Williams, if he was found guilty of murder, he would have been placed in prison. Right. But before he was found guilty of murder, he couldn't participate in the process to fairly determine if he should be placed in prison. But then we as a society placed him in prison. And we kept him there for more than 50 years. And what happened to those 6 persons we referenced is that you go to prison if you're found guilty of offense, but we're keeping them in prison while we try and decide where we can put them.
Right. Right. Catherine, I know stand-up has been in the prisons and in the lockups as well. Mm-hmm. What are the conditions? Because we're here talking about, persons who may never be in a position to defend themselves against allegations before the court, may never be in a position to or to accept responsibility, even in the situation where they may have committed an offense. And they're being placed in these same facilities that we know have had some challenges. I just want you to share for us, what are some of those issues that persist in the facilities that we may be concerned about, especially when it comes to a more vulnerable inmate, like someone who's mentally ill?
I know that in the male prisons, what they do is they may have them on a separate section from the general population, especially if their mental challenges causes them to act out and cause harm to themselves or others. They'll be separated from the general population. So they have an area in each of the prisons that houses persons that are deemed as mentally ill. Pretty much the same conditions that everybody else lives under is what they live under. So there is no what you'd say, there's it's not comfortable. There are no quote unquote.
Yeah, but I mean, Catrian, we'd argue that prison should not be comfortable. So
exactly. But at the same time, it still needs to be, people still need to be treated humanely, if you get what I'm saying.
Right.
So where we would say, okay, we have freedom, and we have proper bathrooms that we can use, we have a bed that we can probably sleep on. Those things don't exist in prison. The conditions are not at all humane. And where I understand that, incarcerated persons shouldn't be quote unquote comfortable, they are still humans.
Right.
Right? There's a lot that, we could delve into, but time won't permit. But mentally ill persons are not treated any differently than a regular person in prison. The most that will happen is they may see a psychiatrist or a doctor more often. But it's nothing to say, throw a parade over, because they're pretty much getting the same treatment that the general population gets.
I looked at some of the comments that came out of Mr. Williams's case. He spoke to sleeping on the floor because it was more comfortable than the foam that he would have been given. He spoke to seeing a medical professional once in a blue moon, which you would think someone who clearly has mental health issues would be on a tighter schedule in terms of how they are receiving medical support.
Yeah, right.
Mr. Clark, what other factors did the court look at when it was deciding particularly on the vindicatory damages?
Before let's go there, I just wanted to make the point that I don't think I've been as clear as I could be on this point. But I really want the state, coming from this particular case, to examine and determine for itself, and the state organ, the government, and if I may, the Prime Minister, to examine the facts of this particular case, but not only for Judge Williams, but also for persons who are currently still in custody whilst they have mental disorders, and ask themselves the question and have the relevant state organ answer for the government the question: is prison the best place to place these persons? And if not, what can be done to ensure these persons are properly taken care of? Before George Williams' case, we have had other cases where the state had paid money, I think a maximum of $8 million for persons who were in custody for a long period of time. But no amount of money that Mr. Williams or any of these persons can get would be sufficient to compensate them for the horror of being a person with a mental disorder and having to endure conditions which were designed to amount to the highest form of punishment the state can inflict on citizens legally. So we asked the relevant, the Prime Minister and his team to examine the circumstances and make a decision as to whether or not the state thinks that something better can be done for these persons to ensure that a middle ground is formed, because these persons have not been, many of them have not been convicted of a crime, but those are the ones who are unfit to play and who have not been convicted of a crime. And they should not, in my humble view, be in any prison. Because those persons who don't have mental disorders, they are invariably in a police lockup, and they're not taken to prison as the first measure for holding them until a trial can be held to determine if they should even be in prison.
Yes.
So to start there by putting somebody in prison is a discrimination that many persons who suffer from mental disorder continue to suffer even to today.
Thank you for that, Mr. Clark. We're going to take a quick break, and then I'll ask you to pick up on your point when we get back.
Yes.
Need reliable security for your business? Dual Protective Security is the perfect choice, providing round-the-clock security solutions and customer support. Our security experts will work with you to create customized solutions that fit your needs and budget. Contact us today and enjoy the peace of mind you deserve with their unbeatable security services. Dual Protective Security. Call 876-676-6987 or 876-415-4564.
Data privacy is getting critical.
Tune in to Cliff Views Online from 10 a.m. to 1 p.m. on July 1 and 2 for the Prioritizing Privacy Conference at the UE Regional Headquarters, Mona. Protect your business and gain a competitive edge. Get expert insights from top minds across Jamaica, the UK, Cayman, Barbados, Bermuda, and more. Learn how to stay compliant with the Data Protection Act 2020, prevent data breaches, and build client trust. Engage in hands-on sessions, real-world case studies, and cutting-edge topics like AI governance, workplace monitoring, and privacy-enhancing technologies. So tune in to Cliff Views Online, July 1 and 2 from 10 a.m. to 1 p.m. It's the Prioritizing Privacy Conference at the UE Regional Headquarters, Mona. Catch the live stream on our YouTube channel at Nationwide 90 FM Live 2. All this and more only on Nationwide 90 FM, the new revolution in media. This broadcast is brought to you by Privacy and Legal Management Consultants Limited. Register now at plmcja.com, where privacy meets performance.
Personal data is at risk. Time to get protection. Talking data defense.
Welcome back to Let's Start Justice. We've been discussing Detained at Pleasure, the case of George Williams. We are joined by Catriona Clark from Stand Up Jamaica and John Clark, attorney at law and chairman of the board at JFJ. Mr. Clark, before the break, you were making a call to our leaders here to take a look into the circumstances of the matter of the case and to look into what reforms are necessary or whether we should continue to apply the law as it has been applied. I think you had another point to make before we took the break.
Why we're particularly making that call is that it is remarkable that despite this issue having arisen before more than 20 years ago, under a previous administration, there were some changes made to the law. The Criminal Justice Administration Act was changed. There were some changes made to the Mental Health Act. But what ultimately took place were that the persons who were in custody because of being mentally disordered, those persons remain in custody. One of those persons was George Williams.
Yeah.
So the lessons that we should have learned in the past when the state had to pay that $8 million was not sufficient lesson to ensure that persons like George Williams were removed from custody. And what I hope, and one of the things that Mr. Williams indicated to us that is that he hoped that the hell that he had to undergo for the last 50 years, he does not wish it on any of his enemies, and he hoped that nobody had to go through what he goes through. So what I'd hope that the state would do is examine the call that the court had made in this particular judgment and then examine the issue of is there a less intrusive method to deal with persons who are mentally disordered, and found that ultimately the state had not in answer to this case, shown that there was no other avenue available to it but prison. And what I hope that the state will do is take that particular call and examine what can be done for those persons who are in the same situation like Mr. Williams to ensure that those persons don't have to file court action, want to get some remedy. And importantly, the first remedy is to have them removed as quick as possible from prison, where they will place them at a mental institution or at a or at some other avenue to ensure that we balance both their right to liberty and the society's concern or any legitimate concern the society may have. But importantly, trying to ensure that these citizens can live their life rather than being in a prison.
Thank you for that, Mr. Clark. I'll take your last word and then I'll go to you, Catherine, for your last word. But Mr. Clark, this, as much as we've articulated why, while the award seems large, it may not be proportionate to the amount of suffering that Mr. Williams would have endured. I know that there's some looking on to say, what are the implications for a decision like this going forward for similar matters? So if you could just, shed some light on that for us and give us your last word before we go.
So I don't understand the question. What do you mean by implication for
future matters? Well, I mean, coming out of, for example, the Everton Douglas matter, we would have seen where many other persons who were detained under state of emergencies were able to bring civil suits and use that judgment as a basis for which they were bringing that suit. So I'm curious to know if this judgment will have a similar effect to those who would have been detained for an extended time under the court's pleasure, the Governor General's pleasure.
It would form some form of precedent and a roadmap for the family members who want to get their loved one out. And they would be able to rely on this, at least in some respect, to press their case home as it relates to what rights are being ventilated. But beyond the monetary compensation that family members may be able to make, and that what its comfort can be derived from this case is that in some of the cases that we are aware of, family members were willing to take the persons with mental disorder from the institution, but they asked themselves the question, how will we find the financial means to care for our loved ones? And for George's family, they had for the last 5 years had to be finding that financial means on their own, and with help from Stand Up for Jamaica and other non-governmental organizations to cover his financial bills and his medical concerns. And what this case does provide is some hope that those family members can get some assistance, one hope from a caring government in relation to resolving this. And I hope, for example, the government could consider whether it creates a scheme, for example, by which those persons can get some form of compensation without having to rush to court to try and fight for a decent compensation. So what one hopes is that this case will be examined in that respect, and that family members can be reunited with their family members who are incarcerated for a long time without being tried, and would for the sole reason that they have a mental disorder. But what one hopes is that this case can provide some form of roadmap into the future to correct some of the miscarriages of justice from the past. And I must also know that the court was very brave in relation to the award it ultimately made, because this award is unprecedented, and the call from the court is unprecedented in terms of the examination of a system in which the government was saying that $60 million was a sufficient award.
Yes.
And finding that despite what the state was saying, looking at the particular facts of this case, and bearing in mind that courts are typically very conservative, finding an award that could somehow bring some comfort to the family after all this time.
Yes. Thank you so much for that, Mr. Clark, and thank you again for joining us. Catherine, just the final word from Stand Up on the matter and on the treatment of mentally ill inmates. What do you want to see the state doing going forward?
We would love to see there be some systemic and policy changes from the government level. Other programs, diversion programs being implemented instead of just taking a, approach to just put them behind bars, if you want to say that. We know that the compensation that Mr. Williams has been given in no way will make up for his injustice, 50 years behind bars without, being sentenced. But we do hope that, it will bring some kind of comfort to his family to know that hopefully payment is made in a timely manner so that he can enjoy a little of the compensation that he has received.
Well, if we did hear our Justice Minister speaking in a sectoral debate, and he indicated that they have no outstanding settlements to be made, so hopefully they would keep on that trend to make those awards in a timely manner, as he would have indicated in that debate, and Mr. Williams will benefit from that. But thank you so much. Yes, thank you so much for joining us, Miss Clark. So we were joined by John Clark, attorney at law, board chairman of JFJ, and Catrian Clark from Stand Up Jamaica. So we're coming up
Thanks
to
for having me.
You're welcome. All right, so I think we would have learned a lot over the course of the show here. I don't see where I have a winner to my trivia question as yet. I do have a winner? Oh, okay. All right, so let me check who the winner is for our trivia question for today. But our trivia question for today was, what section of the Criminal Justice Administration Act spoke to the orders that could be made when a person has been found unfit to plea? Now, I did see the incorrect answer come up a few times in the YouTube chat. I saw section 25.2 or section 25.2a. That section that I see some of you quoting would have been to allow the court to make a determination as to the fitness to plea, right? So there is a section in the act that speaks to the court determining whether or not you're fit to plea. So you're going to come before the court, and the court is going to examine if you are fit to plea. Once the court makes that determination now, and the determination that they come to is that you are unfit, there is another section that speaks to the orders that can be made, right? So that was the section I was looking for. The winner was Moya on Instagram, so we will respond to you in DM with your prize. But the answer was section 25C of the Criminal Justice Administration Act. Section 25C of the Criminal Justice Administration Act. And that section states that when persons are found unfit to plea, that the court may make an order to have the person remanded in custody at a correctional facility, to have the person remanded at a mental institution, to have the person released into the custody of a fit person, or any other order that the court may deem fit, right? As it usually has the power to do. But that is section 25C of the Criminal Justice Administration Act, which was amended in 2015, right? Now, I had something I wanted to cover, but I see that I have 2 minutes, so I could likely cover it next week, right? But just to say, as we spoke to the issue of mentally ill persons, JFJ did do an e-brief on the matter earlier this year that spoke to some of our recommendations, similar to those of Stand Up and the public law chambers, of which Mr. Clark is a part of, asking for certain legislative and policy changes. One of those legislative changes is, as we spoke to section 25C, one of the options, as we said, is to remand the person into a correctional facility. And we heard Mr. Clark charging the state to look at whether or not that continues to be a viable solution for the treatment of persons who are mentally disordered. And our recommendation was to have that section repealed. Our recommendation at JFJ was to have that section repealed. Not simply to repeal it, but to also put in those additional supporting factors, additional personnel, facilities, etc., to place these persons once we have repealed that section. But I think it would not only be good for those who are mentally disordered, but also those officers, correctional officers, who do not have appropriate training to deal with mentally disordered persons and are being burdened by their inclusion in the normal correctional system. So we join Mr. Clark's charge to the state to take some heavy scrutiny as to what this judgment said and look at how we can improve the situation for these mentally ill persons. But that was Let's Talk Justice for today. My name is Jade Williams. I'm the Policy Research and Advocacy Manager at Jamaicans for Justice. We'll see you next week.
Jamaicans for Justice, the people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or Jamaicans4Justice.org.
The people's champion.
Calling all businesses. Nationwide 90 FM's Back to School Fair is